honor to introduce our distinguished speaker for today's session is Advocate Dinesh Chaturvedi sir. Advocate Dinesh Chaturvedi sir is a three-year law graduate from the reputed Banaras Hindu University and hails from Katni, Madhya Pradesh. He completed his undergraduate in history from University of Delhi and then pursued his master's degree. During his days at BHU, he was an active member of the Legal Aid and Service Clinic. Intellectual property law has always been his inclination, and he did his internship from reputed Tier 1 firm Intel Advocate. After finishing LLB, he joined Triambak Overseas, a boutique IP law firm, as an associate. Since then, he has enrolled himself in the Bar Council of Delhi and received his trademark agent registration. His role in the firm has been to handle the drafting work, client consultation, representing clients in the hearing in the front of the trademark registry, and representing his firm at various platforms such as Business Network International. Currently, he is working in the capacity of a senior associate leading a term of freshers. He reads IP judgments on his commute to and from work. In his leisure time, he likes to read, swim, and cook. He is also a prolific commenter on LinkedIn where he posts about the various aspects of the IP law and engages with the legal fraternity. I kindly request all participants to keep their microphones engaged and their videos turned off during the session. If you have any questions, please save them for the end when the speaker invites you to ask. Without further ado, let us warmly welcome Advocate Dinesh Chaturvedi sir to the virtual stage. We eagerly await the invaluable wisdom and perspectives he is about to share with us. Over to you, sir.
Paras, am I audible?
Yes, sir, you are.
Okay, so first of all, a very warm thank you for giving such a humble introduction to me. And I want to acknowledge that you had invited me for this webinar. I wasn't expecting at all. When you reached out to me, it was not on mind anywhere that anyone would reach out to me for a webinar like this, and I would get an opportunity to transfer my the knowledge that I have gained for the past few years in this IP industry to aspiring law students. To begin with, uh, I I'm sure that all of you must know something about intellectual property. Intellectual property has been my inclination, not because it is interesting. All fields of law are interesting, no doubt. Anywhere you want to pursue taxation or corporate law or fashion law, media and entertainment, criminal, civil, anything, whatever you want to pursue, it is interesting. The reason because I chose intellectual property was because I found it easy. I tried my hand at corporate law, I tried my hand at taxation. All of it seemed very complicated, but intellectual property came naturally to me. So that was my that was my final choice to pursue my career with. Now intellectual property is something that is all around you, that you see every day in your life. There are other aspects of law that you might not see. Criminal law you might not see every day at action. Civil law you might not see. Once in a while you might see a property dispute or marital discord, and you might think that this is the field of law you might want to pursue. Intellectual property is something that comes across your eyes every day, from the brand that is etched on the back of your phone, to the technology that runs your phone, and to the content that you watch on your phone. Everything is copy, everything is intellectual property. Intellectual properties introduction, the basic introduction to intellectual property would be something that my professors taught me, was that intellectual property carries two basic features. First of all, it does not need a physical proximity to you or just one person to be entertained. Like a land, to enjoy a particular land or a flat or a car, you need to be physically proximate to it. But intellectual property is something that many people can enjoy from far away, like copyright. Even if the even a writer has written something that he has uploaded online, a number of people, innumerable, infinite number of people at the same time can enjoy that property. Okay, and it does not need a physical ownership. It is not under ownership of one person. You might buy a book, but that book itself is a container of intellectual property. That book is a tangible property. You can touch it, you can feel it, you can have it in your cupboard. but the intellectual property contained inside it, that is the content, that came out of the artistic creativity of the writer, that can be enjoyed by multiple people at the same time. Basically, if you want to pursue a career in intellectual property, then you would come across four types of intellectual property that are the core essence. There are intellectual properties other than that also. First of all, there is trademark. The trademark is most common, most pursued field of intellectual property because it is everywhere. Okay, it is easily understandable. Even a layman can understand the concept of trademark. Then there is copyright, and then there is design and patent. Patent would require an additional set of qualification. Those of you who have pursued BTech or BSc as an undergraduate subject, or somebody who has taken BSc LLB as their 5-year law course, only those students would be allowed to pursue a career in patents, because you would require a qualification of patent agent. Every year there is a patent agent examination which only science students are allowed to attempt. Now, those of you who are from commerce background or from arts background would have to do with trademarks, designs, and copyrights. The other intellectual properties would be trade secrets, Biodiversity Act, geographical indications, semiconductors, layouts. But these are not something that comes across your desk every now and then. These four intellectual property field arenas, that is trademark, design, copyright, and patent, that is something that you will, if you start to pursue a internship career or a full-fledged career in intellectual property, you will see these every day. Now, to give you a basic introduction of these four, trademark is a mark, as it says in its word itself. It is a mark that will represent the quality of goods and services that is originating from a particular source. For example, for recently, Haldiram has been declared as well-known trademark. I will come upon well-known trademarks, what is it and what are the nuances. Now, Haldiram, you see that oval shape, you see that white font written in italics on a red background, and you automatically know that this is something that will give you quality. You know that it manufactures aloo bhujia, it manufactures sweets, it manufactures other snacks, and you are very much sure of the quality that you will get. This reputation is built upon a mark. You never turn the packet and you see if it is coming from the same manufacturer. It might be a fake product. Okay, that is what the essence of infringement is. So that particular mark which you see upon a product, and you automatically assume that you are going to get a good quality product, and you are going to get a consistency, that is called trademark. Everyone uses a trademark. Any business, any kind of educational institution, any kind of enterprise, these might not use patent or copyright on a daily basis, but trademark is something that is present everywhere. The name of your college is most probably a registered trademark. Okay, the publishing houses that print your books that you read on your daily basis, those are trademarks. The brands that you wear, that the clothes, the phone, the watches, the shoes, everything has a brand name that gives you an indication towards the source of that goods or services, and that is a trademark. Now, coming to copyright. Copyright is something that is created from the artistic or intellectual creativity. You might write an article, okay? You might click a picture, or you might draw a painting, or you might create a video, okay? Copyright has many sets of subcategorizations. Artistic works contain pictures and photographs that you click. Now, there are cinematograph works like movies that you see. Now, there is literary work like novels, articles, or research papers, and many more. So copyright would require just a decent amount of intellectual creativity. Now, you all write assignments and research papers every 6 months. You take material from internet. You go to internet, you search what your topic is, and you take some portions of it, and you write your own. You create something from your own. Now, if a major portion of it is copied, if you are trying to be lazy, if you are trying to just pass your semesters, you might take the whole article from some website and you might write it down in your handwriting and you might submit it. Now, that would not create a intellectual property of your own. Intellectual property, even though it is intellectual property as in copyright, even though it is taken from other sources, you have taken inspiration from other sources, But if you have added these a little amount of your own intellectual creativity into it, your own artistic capabilities, then it becomes copyright. Now coming to design. Now I am sure, very sure that any one of you would, if you touch the bottle of Coca-Cola, even if your eyes are closed, if you touch the bottle of Coca-Cola or you touch the bottle of Bisleri, you can, just by touching it, you can identify that this is from Bisleri or Coca-Cola. Design is the aesthetic aspects, the visual aspects of a product that make it appealing. You might go to, you will go to a you will go to a handbag store, and you look at hundreds of handbags, and out of them only two or three will appeal to you. You will want to buy them, and you would want to own them, because the design, the appearance of that product is so much appealing to you that you want to associate with it. This is design. Design are the ornamental aspects of any product. These do not apply to services, obviously. Designs are only confined to goods. So design is something that also contains intellectual creativity, because there are so many designers who are working hard to create unique designs for cars, for handbags, for shoes, for televisions, for clothes, or bottles. It can be from fashion industry, it can be from the industrial complex. So design is that aspect that you can see, and it is appealing to you. Now coming to patents. Patent is basically invention. The one word that you can associate directly with patent is invention. If you have created something is uh, that has a economic significance, and it has a novelty, not NOBEL, it is NOVEL, novelty it should contain. If it has, if see, you are surrounded by technology, but people are working to improve it. If they have added an inventive step into it, if they have added something that has made it better from what was already present in the market, and it can be of economic significance. Not if you have only added an inventive step, if you made something new, but it cannot be economically viable, it cannot be present to customers on a mass scale, then it won't get a patent registration. It has to have an inventive step, plus it has to have economic significance. These two, when combined, they will give you patent registration. Now to talk about the term of these intellectual properties. Design, copyright, and patents have limited time frame for their protection. The concept of intellectual property is, in the case of design, copyright, and patent, is that you will give the government the information about your intellectual property. The government will protect for you for a certain period of time, and after that, that information comes into the public domain. What that means is the patent is protected for 20 years. Maybe for example, a company like AstraZeneca or Sun Pharma is developing a new drug. They are trying to cure COVID or malaria or typhoid, anything. They come up with a new drug, they get it patented. There is something in that drug that makes it more efficient than all the medicines that have come before it, and it can be sold to the consumers at an economically viable price. That means it can be profitable to the developer, the manufacturer, or the people who are the researching over it. Now the government will, they have to submit an application in which there are two steps: provisional specification and complete specification. What these two forms require the inventor is to provide all the information, the chemical formulation, the process to manufacture it, everything to the government. Now the government will protect their property from other people who are trying to copy it, because in multinational companies spend years and millions in money and resources to develop something new. And if any other party would be allowed to copy it just by taking that pill, reverse manufacturing it, and copying that formulation, then it won't be fair to the inventor. Then why would you go on inventing, or why would you spend your time and resources to invent something if you are not being protected? If other person can just leisurely sit for years at their home, and when you come up with something, they just take it from you and they make money. So the government will protect you for next 20 years. Only you will have the right to manufacture and sell that product, and you can earn more money than you have spent on it. Now obviously most of the researchers, they are professors at different universities. Even at your university you might have science department, and there are people working on different technologies, so they can license it to other parties. Maybe there is a company who wants to manufacture something, but they do not have the research or development capabilities. A university has professors and scientists working on something, so they have invented, they can get the patent registration, and then they can license it to the other parties. License is a limited period and a limited right given to other parties to do an act which is originally the right of the owner. Okay, like giving your property on rent, you can give it for a limited period of time, you will get a rent amount, that is your benefit, that is your profit, and you can sit back and relax and enjoy your property because you have already spent your time building that property. So why would you now maintain it? And that is the headache of the person who has licensed or rented it from you. Similarly, design and copyright are also limited period time. Design is 10 plus 5 years one time, because the patent, any kind of medicine or any kind of technology becomes old with time. Now you might have seen radio transistors at when you were little, and now you have mobile phones in the palm of your hand. Okay, so technologies become old with time, they become non-relevant, so their protection is limited. Similarly, design, any kind of product that you find appealing today, you might not find appealing it 6 months after, so let alone talk about 10 years after. So design protection for any kind of product like a sofa. Now you might have seen different kind of couch designs at your nani's home when you have gone for your summer vacations, or you at your own home, and now you see that couches have changed, their designs have changed, the designs of your televisions have changed, the designs of door handles have become more elegant and more angular. Earlier there used to be big knobs that were more ornamental, and they used to make you feel like some kind of king or a queen. And now you have more angular design, more sustainable designs have come up in the market. So design is something that won't be protected for infinite amount of time, because it becomes old, people will not find it appealing in coming years. So design has a protection of 10 plus 5 years. Originally you can get 10 years of protection, then 5 years of extension over it. Copyright is till the death of the author plus 60 years for beyond that. So a movie which was created in 1940s, and then the producer died in 1980s. The producer is the author in the matter of a movie. So author is a term which is different for different kind of copyrights. For a painting, it is basically painter, and for cinematograph films like that is movies or documentaries, it is the person who invests money into it, so it would be the producer. So after the death of the producer, till the death of the producer, it is protected. Even after 60 years after his death, it is protected. After that, that movie comes into the public domain, and the public can share it, public can produce it, it can replicate it, they can copy it on CDs, pen drives, or whatnot. Similarly, but trademark is something that is different. Trademark has an infinite time of protection. Trademark is something that shows brand value, brand trust, and it grows with time. You see every 10 to 15 years that companies, brands change their logo. Why? Because they want to keep it relevant to the public, even if they do not change. Like Haldiram's logo hasn't changed for a long time, a long period of time. That logo has become a symbol of trust, a symbol of quality, a symbol of consistency in the mind of the customers. Now customers, when they see something, that logo on a product, they will recognize that this is something that they want, that this is something that they have already tried and they have found it satisfying, they have found it pleasurable, and they want to buy it again. So trademark, as it grows with time, trademark gains more value, it becomes more valuable, more pricey. Why do I say pricey? Is because trademark has a price, it has a value, it has a value in the minds of customers in the form of emotions, abstract qualities. Then it also has a quantifiable price over it. Like if you simply search on internet that what is the highest highest valuable brands across the world, you will find Google, you will find iPhone, you will find Microsoft, etc. Whenever a company buys, you might have heard that Reliance is buying Hamleys, or Reliance is buying other companies, other smaller companies. Most of the time what they are paying is not for their that business itself. They are paying for that brand. That maybe Zomato was acquired by someone, maybe Blinkit was developed by some other parties, then it was bought by some other parties. What the buyers bought was the brand value, the brand trust, because the business can be developed by anyone, but that business, the customers don't know about that business, what all goes behind the curtains of Blinkit. They just know that when they see a yellow colored box of Blinkit, they know that they will get their delivery within time. So if somebody wants to buy Blinkit, they are not buying the Blinkit bikes or Blinkit's delivery man or the Blinkit's warehouses only. They're buying that trademark, that brand value that will allow them to continue. Now, imagine if Coca-Cola has many kind of intellectual property. They have trademark in the form of that symbol, that italic writing. Then they have their design, the unique design of their bottles, and then they have trade secret also. The formulation of their cold drink is still a trade secret. Okay, so if all their factories, all their machineries, all their trucks, all their labors, they just vanish one day, all that they have, all that remains is just the intellectual properties, the know-how of the formulation and the technology, the design of their bottle and the brand logo. They can build that business again within few years. So that is the value of intellectual property. Now, earlier, what a valuation of a company is, what assets it owns in the form of tangible or intangible assets. So earlier, I would say 20-30 years ago, whenever a company was valued, it was valued only for its tangible assets, the land it owns, the workforce it has, that the machineries it carries, the vehicles or other forms of tangible properties. What trend has changed in last 20-30 years is that now when a company is valued, it is also valued for its intangible properties. What brand does it what brand value it has garnered over the years. For example, in 2015, Maggie faced some serious charges that their product contains a huge amount of monosodium glutamate and lead. Now, what it caused was a decline in their brand value, because the losses that they were facing, that will be recovered in a few years. They will just raise their prices of their packets by 2 rupees, and they will cover all the losses whenever the ban is lifted. But once a company's brand value declines, nobody trusts it. Okay, so what Nestle did for Maggie was they started making ad campaigns. They made emotional ad campaigns about how a mother cooks Maggie for her children, how boys or girls living in hostels away from home, they cook Maggie for themselves. So these kind of advertisements were to maintain their brand value, even if in reality they were facing serious allegations. Okay, so for a customer, for a consumer, for people like us, we do not have time to ponder upon what a company is making. We generally trust their brand value. Recently, Born Vita has been facing serious allegations about how much sugar do they contain in their product, and even companies like even products like Cerelac for kids, it contains a huge amount of beyond a limit. They contain pesticides. Now, for an average consumer, they might not think about it, that what all is going on behind the curtain or what all it is in news. They, until and unless they trust the brand value that Cerelac or Bonvita is good for their kids, people will buy it. And beyond that limit, when the trust declines, even if the company improves their products, even if they comply to the government mandates and the government guidelines about the contents of the product, even if they change it, even if they improve it, even if they comply with the government guidelines, but once the brand value declines, nobody is going to buy it. That is why these companies, these brands on Twitter, they fear the cancel culture or the boycott campaigns. Why? Because once they have done something, they have uploaded an ad, maybe it has hurt the religious sentiments of some parties, and they call for boycott of the particular company. They are not afraid of the losses that they will face in the terms of sales, because that can be recovered by just by producing more products, or by raising the value of the product by a little margin. That is recoverable. But what isn't recoverable is the brand value, because it has been built over many years, because they have spent infinite amount of resources, a large sum of our resources, to bring that brand value to the level where it is today. The companies regularly create ads, they publish they publish pamphlets, they come on newspapers, they come on televisions. You see advertisements everywhere. What is advertisement? It is building of a brand. you might have heard this anecdote about Red Bull, that Red Bull wasn't a profitable company when it was launched into the market. So what Red Bull did was they left empty cans of Red Bull drink outside pubs and bars and discos and clubs. So what people started to think that this thing is already being sold at a big scale. So they started to buy it. So trademark is all about brand value and what can be done with it. Now that you have understood about trademarks and other kind of intellectual properties, what career can you make out of it? Now, as I have told you that my motivation to come into intellectual property was because I found it easy, but this is a very subjective opinion. You might find other fields of law easy. Intellectual property has a relevance in all times. In India, after the liberalization era in 1991, foreign companies, foreign brands came into India, and India had to comply with TRIPS, trade-related aspects of intellectual property. It is an international agreement that is signed by multiple countries, and they have to comply with a similar set of rules to protect intellectual properties of one country into other countries, because intellectual property per se is a territorial right. Okay. If I have a registration in India for my trademark or my trademark or patent is only protected in India. If somebody takes my property, my novel that I have protected as copyright, and they publish it in other country, they make copies and then they start to import and export it, I won't be able to protect it solely on the basis that I have registration in India. Okay. So intellectual property right is a territorial right. So to protect it internationally, many conventions have come forward. The main of it is the most crucial of it is trade related aspects of intellectual property, in short TRIPS. So after TRIPS was introduced, India changed its trademark act. We got the new trademark act in 1999, and we got the Designs Act in 2008. Yeah, and after that we got Biodiversity Act and semiconductor layout, geographical indications, all of that. So intellectual property became very important after the 1991. Okay. Now since then India has changed their statutes also, and although intellectual property is not a niche field of law as of now, because what I would call niche right now would be artificial intelligence and data protection laws, but intellectual property is what touches many of those aspects. Even you have heard this buzzword artificial intelligence and how it is going to affect different industries, but out of that we hear that what is the intellectual property, who is the owner of a picture or an article that is written by intellectual property. Okay, so these questions are also arising along simultaneously with the advent of artificial intelligence. So even though intellectual property is not very unique field in itself, but when it is attached with other fields, when it is attached by media laws, when it is attached with telecommunications, when it is attached by sports industry and fashion laws, then it becomes unique again. So it has intellectual property has stayed relevant since 1991, and I see that intellectual property is going to be relevant still, because intellectual property is what propels an industry forward, what propels the economy forward. Okay. So intellectual property is a very good field of law to pursue with. There is so much to do. There are different levels of corporate firms. There are tier 1 firms, tier 2, tier 3. Wherever you get an internship or a job, you will learn a different set of things. For example, if you get an internship or job at a tier 1 firm, you will be given much more guidance in terms of drafting work or the procedural laws. In smaller firms, you might get more freedom to try yourself, to draft or to play with the procedural laws. You will get more independence in that, because I say that because most of the times students are worried that they have to get an internship in tier 1 firms only. Okay, but as you know, the tier 1 firms have a very high set of standards to select their interns. They would expect their interns to have the same level of knowledge that smaller firms would expect from their associates. So not everybody can get a internship at a tier 1 firm due to the limitation of seats also. Any kind of firm that you can get, if it is a trustworthy firm, you should get an internship there, because no matter where you start with, you will learn a lot. Now I got the opportunity to intern with Intel Advocare, where it was my first internship in intellectual property, because before that I had tried criminal laws and civil laws at the High Court of Madhya Pradesh. Intellectual property intrigued me in terms of drafting work. Also, there are 2 3 aspects of intellectual property in terms of procedure. Now there is the prosecution part, that means the search work of a intellectual property, the filing and the registration part. Then there is opposition part. Whenever an intellectual property is registered, the government allows other parties, the public, to oppose the registration in case there is a conflict of interest. So there is an opposition part. There is an enforcement part. Whenever and somebody tries to infringe a intellectual property of some other party, then you can file for temporary injunctions into the court, and you can get the order for raids. You can the trademark attorneys go with the police and they conduct a raid, they seize the infringing products. So this part of the trademark, the intellectual property industry, is called the enforcement part. Then at the last, there is litigation, that is present in all kind of field of laws. Litigation is where you file a case in the district courts or the high courts, depending on the jurisdiction, territorial as well as pecuniary, and you will file for the to get your rights in your favor, and to get damages for what all you have faced. Okay, so for trademark registration, first of all, whenever you will get a trademark, when for assume that you are on an internship, and or you have joined some firm as an associate, you will get you are approached by a client, and they say that they want to manufacture shoes, and they want to name something, they have to adopt a name for their shoes. Either you suggest them some words, some logos or some trademarks, or they come up with their own. Now when they come up with their own, they want to get it registered right away, as the mentality of a businessman would be, that they want to secure it right away, they have to secure it as soon as possible. What you as a trademark attorney have to do is, you have to conduct a search. You have to see if similar trademark exists in the Indian registry or on the global brand database. Because if somebody else has a similar or identical mark protected in their name, then you are going to face infringement charges. So first of all, the first step is to search it on Indian registry website and globally. Once you find that the marks is clear to be registered, then do you file for application. Now there are two kind of trademarks. One is a word mark, a simple word like Haldiram or Lava or Fast Track. Now then there is a device mark type. Device means a logo mark, where you have a word, maybe you don't even have a word, you have kind of a symbol, like Puma has a panther on it, like Nike has a whoosh mark on it. Okay, so there are two kinds of mark, word and device. You have to first bifurcate if there is the trademark that is to be registered by the person is he wants to get a word mark registered or device mark registered. Word mark gives you the protection across all forms of words. Now if you have a word protected in your name, then you can write it in any form. Okay, and you will get protection over it. Even if other parties try to write it in italics or in other kinds of font, you can stop them from doing so. And device mark has a very specific protection. You will get the protection only on that kind of representation that you have filed for. Okay, nothing else. Even if you change your device mark by a little bit, you have to file a fresh application. Then there is a categorization of product and services. Trademark has been divided into 45 classes. Okay, classes 1 to 34 are for goods like machinery, for oils, for clothing, for shampoos, for medicines, for machineries, for trucks, any kind of product that you can hold in your hand or you can touch or you see. And then classes 35 to 45 is for services like legal services, medical services, advertising, promotion, event management, rental services, hotel management, etc. So then you have to find the correct class for the product that is being the product or service that is being launched under that trademark. Then you have to see if the trademark is being already used or it is proposed to be used. User claim is very important in India. India as such is a user specific country. Even if you don't have a trademark registration, but if you have been using it for many years, then you have a right over it. Okay, you have a common law right, not a statutory right, but a common law right. For example, many of your parents or siblings or friends might be doing their own business. Okay, they are entrepreneurs, they are running shops in your hometowns, and the name of your shop might not be a trademark, but that does not mean that other parties can copy it, because you have been using it in the market and people associate that mark by the name of your business. Then other parties cannot take it. But trademark registration is still suggested, because not having a trademark registration would create legal complications in case of infringement. For example, if I don't know how many of you are from Delhi, but in Delhi there is a very famous momo joint called Dolma Auntie Momos. Okay, it was opened in 1994, and the owner Dolma Auntie Dolma Sering, she never imagined that what success she could reach. So she was a mediocrely literate person, and she did not know about trademark registration. So she just started her business. But by today, she has 5 different locations from which she sells her momos. Her momos are known across Delhi. Okay, but she never filed for trademark registration. In year 2020, someone from UP started to infringe her mark. Say they started to sell frozen momos in the name of Dolma Auntie Momos. So you see, even if you are using your mark from a long time, even then you need a trademark registration to secure yourself in the eyes of law. Okay, she had to fight, Dolma Auntie had to fight a case in the Delhi High Court, and it ran for 3 years. And then he got the other party to stop selling those products under her name, and she also simultaneously got the trademark registration. So at the end, she had to register and secure her trademark. So usage is very important in India. If maybe you had started a business 20 years ago, you did not get a trademark registration, but you can get it now. And trademark registration is applicable from the date of your application or from the date from which you have started using it. But you have to prove that you have been using it. You cannot just go out and outright claim that you have been using it from 10 years and the registry will grant you a protection from the back date. You have to prove it with cogent evidence. The evidences would be invoices, the bills that you generate, that you have been having, that you have been conducted such a huge amount of business, such a huge scope, and the product has been reaching so many territories. You will show that you have spent what amount in advertisements and for ad campaigns. Maybe you have hired a media celebrity as your brand ambassador, so for that you have spent money. So you have to show that your mark has already gained recognition in the eyes of people, in the eyes of ordinary customer, and then you will get a trademark registration from backdate and for the next 10 years, and then you can renew it for infinite amount of times. For every 10 years you will get the right. Okay, so when you file for a trademark, then there are other details: the applicant's name, applicant's type, whether it is a company, it is an individual, it is a trust, or a limited liability partnership. For every kind of category, there is a different fees. Okay, for individual, it is 4,500 rupees government fees, and for other categories, it is 9,000. But if you have a certificate, if you are a startup or you are a medium small enterprise, then you will show your certificate and your fees would be reduced to half. Then you apply. Then there is a small stage called formalities check. Okay, the registry will check if your mark has been filed properly, if all the documents are correct. One very crucial document, two very crucial documents would be power of attorney, where the applicant would authorize you as their trademark attorney to file for their trademark. Okay, like you have in civil and criminal laws, you will hear the word wakalatnama. In trademark registry, it is power of attorney. And the user affidavit: if somebody has claimed that they have been using this mark for past this many years, then they have to sign a user affidavit claiming, and they have to get it notarized from an oath commissioner that you are claiming it on as an oath, and you have to support it with evidences. Now when you filed, formalities check would be passed. Then there is an examination report. The trademark registry would list objections. The objections are mentioned in section 9 and section 11 of the Trademarks Act. You can read it after the webinar. I hope you read it because it is very interesting. You would find how brands fight amongst each other to secure a trademark. Okay, so the trademark registry would raise objections. Then this reply has to be filed by the trademark attorney within 1 month. If the reply filed is satisfactory, then the mark is accepted, or if it is not satisfactory, then there is a hearing. Okay, the hearing is allotted. The trademark attorney has to appear in front of the hearing officer. It can be virtual, it can be physical, and then they have to defend their marks. Either it will be refused, or if it will be accepted. Now after this acceptance, the trademark is advertised for the general public. Okay, maybe say, imagine that you have a trademark in your name. How would you come to know that somebody else is trying to register a trademark that is similar to yours? That is found in trademark journal. Every Monday a trademark journal is published by the trademark registry that contains all the accepted marks of the previous weeks for different classes. For every class there is different PDF. and there are the advertised marks. If any third party, if any person from the general public has an objection to this advertised mark that the registry has granted acceptance, they can file a notice of opposition within 4 months from the date the mark comes into the trademark journal. From that, this mark has to be opposed within 4 months, and then there is a whole procedure that can be read from rules 42 to 48 of trademark rules 2017, and you will find that there is notice of opposition, then the applicant submits a counter statement, then there is evidence stage, and then there is hearing. And if the favorable order does not come to you, then you can go to the respective high courts for to plead your case. Okay, so trademark process is very easy. It is not very difficult to understand. What is difficult is the logistics, because when you start working as an intern or associate, on daily basis you will get multiple dozens of mark that you have to file, you have to check for, you have to create an opinion, you have to what is the most difficult part is to explain it to the customers, explain it to the applicant who has come to you to file, because they have many aspirations, they have created a mark that they find very unique or very appealing to themselves, but from the eyes of the law it might not be very unique, it might not be eligible for registration. And then you have to consult, you have to give consultation to client how they can navigate the laws and they can get the registration in their favor. Okay, so all in all, the trademark and IP industry is a very interesting industry. You cannot imagine what kind of people you can meet in this industry. I would not take names, but many of the social media influencers that you might hear, that you might watch on YouTube, they are our clients, and they are the clients of other IP attorneys that I know. So intellectual property is not restricted to intellectual property. When you get into this industry, you will find people who want to get their trademark registered. Maybe it is a YouTube channel, it is a social media influencer, it is a cosmetic industry owner, and you can interact with them. There is a huge and there is a wide horizon that you can capture. You can later switch into other laws. The intellectual property laws are very associated to pharmaceutical laws, okay, media and entertainment industry, sports law, and fashion. So once you have taken your first step into intellectual property, then you can get to other field of laws also. And it is not restricted. It is not like that you will spend all of your life in this industry on law. You can switch between the industries, and you will get many different types of horizons to capture. Okay, now I think I have taken a decent amount of time out of our webinar. Now I would request the participants to ask any questions if they have any. I would hope you will ask questions. Paras, if you can open the chat box.
Yes, sir. I have opened the chat box. If
Okay.
anybody have any query, you can write in the chat box.
Paras, do you have any query from the all that I spoke in this webinar?
No, sir. I learned very well about the IP trademarks.
Okay. So Paras, what is your preferred field of law?
Sir, my preferred field is criminal law.
Okay, your criminal law. So have you been interning or have you been practicing?
Sir, I am interning.
Okay, so where have you interned so far?
Sir, I had interned in the Supreme Court Advocate, Miss Monica Hussain, ma'am. I
Okay.
interned in the Jodhpur High Court,
Okay.
Devendra Singh Thing, sir.
Okay. So have you tried your hand at intellectual property yet?
No, sir, not yet.
Okay. Intellectual property is also covers criminal infringement. Criminal punishment is also prescribed under the trademark law. Okay. So maybe if you ever want to expand from serious crimes like theft or dacoity or murder, etc., then trademark and patent infringement also carry one very serious punishments. It also covers the domain of criminal laws. So maybe you will get to experience in that way.
Sure, sir. If any participant has any query, you can write in the chat box.
Hmm. Okay, so you are a 3-year law student and you are in your second year. Okay, Priyanka. So Priyanka, I would like to tell you that my law started and then COVID hit it. So I could not do any internships in intellectual property per se, and I got the opportunity to intern in my third year. Okay, So it is not a hurdle for you that you are in second year and you have not started in this field. You, whenever you are set to get a vacation from your college, you have to search, you have to first decide which place you want to intern it. And every state have economic zones. Okay, in Madhya Pradesh, for example, it is Bhopal and Indore. In Maharashtra, it's Mumbai. Here in Delhi, also, every state you will find intellectual property industry. So you have to find tier one firms, tier two firms. You have to get the list of those firms. You have to then find the communication details of each firm. And when you go to write an email in those for those firms for applying for internship, then you don't write a blank email or a very plain or a very generic email that I am very interested in intellectual property and I want to get an internship. What you have to write is very short cover letter, and you have to properly show that you are genuinely interested. Write an anecdote, short anecdote that your father does a business, your mother does a business, or how you know, for how you have come to gain interest in intellectual property. And then you create a CV which somehow shows, even if you do not have an internship in intellectual property, you can take free courses from Swayam platform and from World Intellectual Property organizations. Those intellectual property courses will vouch for you that you have an interest in intellectual property. And then you can, if you apply after that, maybe you are in second year, so you have ample of time to pursue 1 year, 1 month or 2 months courses. Once you have done those courses, your CV will reflect that you have an interest in intellectual property, and the person, the HR manager who is looking at your CV will be impressed with you, and you will get a chance to get a start in this field. Okay, but first of all, you have to show that you have an interest, because they want people who will genuinely work in intellectual property, not just because they want to cut time from their college vacations. Okay. Sejal is asking that in case of Dolma Aunty, if in that case the person from up who UP is who used it first files for trademark, then can anything be done by first party? Obviously, good question. As I told, India is a use specific country. User is given more weightage than registration. Now Dolma Aunty has been using that mark from 1994. The other person registered it in 2020. The other person did register it, he got the registration. Okay, but it got rejected after the Delhi High Court verdict. Why? Because the the hard work behind that trademark, the trust, because when a person would see Dolma Aunty trademark in on the name, on the product of that other person from UP, he might think that it is from Dolma Aunty. Trademark is all about customer confusion. If the customer gets confused and is led to wrong product, then the court will injunct it, then the law would stop it. Okay, so even if this other person gets a registration in 2020, even then Dolma Aunty won that case, because she has done all the hard work. She has done 20-30 years of product. She has been selling for 20-30 years, and people associate that mark with her, with her quality, with her value, with her trust. So yes, even if somebody gets a trademark registered similar to yours, but if you have been using it from an earlier period of time, then you can stop them even after registration. Definitely. How can a fresher start working in IPR without any prior experience in field? Shadab, as I replied to Priyanka earlier, you have to show intellectual property. You have to show that you have an interest. So if you can directly go on the Swayam platform. It is a government's platform where there are free courses conducted by IIT Kharagpur, IIT Madras, NLU Delhi. Many recognized organizations conduct free courses. You just have to pay for a certificate exam. Okay, and World Intellectual Property Organization also conducts free courses for beginners. So once you have done those courses, or you have written a research paper or an article, you have published few articles on intellectual property that show that you have an interest in intellectual property. Okay, because believe me, for as long as I have been on this job under Triambak Overseas, I have seen many CVs. I have gone through around 200-300 CVs in just 1 month. And what I see is, if I want to take an intern, I want to see they have already done something, even if if they haven't done an internship per se, but they have some interest in the form of certificate courses or research papers. So once you show that interest, you can definitely get experience in this field. Okay, and those courses I'm talking about on Swayam and Vipo, they are a experience in themselves. Okay, they will teach you so much. There are quizzes, there are in international interaction platforms. You can interact with other students across the globe who are studying that. You can discuss those topics on the Vipo website, and you will get a lot of experience. Okay, sir, can list some of free courses here, please. Just search Swayam, okay, SWAYAM, Swayam. You will get the website. It is approved by NPTEL, okay. And if you want, I can give you the link also here. Just a second. Swayam platform. I also began because to begin with, I did not have any experience in intellectual property. So I began from here. I started doing courses here. I did 2 courses, and one I could not finish. Although I did finish the course material, I could not give the exam. One I finished. This is the Swayam website. There you can find intellectual property courses. There are 2 month courses, 3 months courses, and there are advanced level courses, and it is all free. Okay, so from there you can start your journey in intellectual property. And intellectual property courses also are there from Vipo. Just search distance learning courses. Just a second, I would share the link here. Okay, these 2 links would help you a lot in gaining experience in intellectual property. Okay, because for some reason I see that intellectual property material cannot be found on YouTube has very little material over it, so these courses would help you. Samruddin Nayak, good evening. Is there any question you want to present? You can write in the chat box. Deepak, sir, I have enrolled in Swayam course by NLU. Very good, Deepak. I hope you find that experience enriching, and you can apply for internships. Even if you have enrolled and you haven't finished that course, even then you can in your CV you can write that you are pursuing this course from this college under this platform, and what you have learned so far, and when it will end. You can write this one paragraph in your CV, and that will make your CV much more appealing to the HR than it was before. Okay, so your chances would increase significantly. Any other question from the participants?
If anybody have any query, please write in the chat box.
Deepak, how internal assessment is done in Swayam? You have to regularly. You have to after every course, every material is released online. You have to submit a quiz over it, quiz based on that course material. And at the end of the course, there is an exam scheduled. You have to fill that form. You have to pay a nominal fee, and after attempting that exam, you will get this certificate. So that is how internal assessment happens at Swayam. Thank you, Shada, for taking time out of your weekend to join my webinar. I was not expecting that so many people would stay by the end of the webinar. I'm so thankful to you all. I'm so thankful to Legal Vidya and to Paras for contacting me for this webinar. It was a great experience for me as well. I was not sure that I would be able to speak for this long. And I regret that I haven't prepared a PPT for your comprehension. I hope you all grasped whatever I have said here. Thank you, Priyanka. Thank you for your time. Paras, I guess everyone is done here.
Yes, sir. Thank you so much, sir, for such a wonderful session on IP trademarks and IP industry, and I have learned also very well. So now I would like to call our founder, Miss Sakshi Sharma, ma'am, for vote of thanks.
Thank you so much, Paras. Good evening, sir. I hope you're doing well today.
I'm doing very fantastic. Sakshi, thank you for calling me for this webinar. Thank you for this opportunity.
So, thank you for joining. It was an amazing session, and I myself have had mostly my interest in criminal. But after your session, I've peaked interest in IP as well, so I might as well try that. So, thank you so much, sir. It was an amazing session, and I look forward to having more sessions with you.
Definitely, if I get an opportunity next time, I would come over with a PPT so that you can understand well, and we can we can conduct a webinar for one step above for particular kind of intellectual property. Okay, so I would look
Definitely,
forward to
sir.
it as well. Uh,
Definitely, sir. It will be an honor for
Yes,
us to have
it
you.
is. Anubhav Gupta is asking for some courses. Anubhav, if you could, I would give you the link to my LinkedIn, okay? And you can message me on LinkedIn, and I will suggest you courses that you can do for intellectual property, artificial intelligence. Even there are some international uh, YouTube channels, okay, that are providing good amount of knowledge on artificial intelligence as well as the legal aspects of it. So this is my LinkedIn account. You can message me and I will send you the information on the courses. Okay.